does the NLRA define collective bargaining? Imagine workers and employers sitting down at a table, trying to reach an agreement about wages and working conditions. How does the law guide this process? Well, the National Labor Relations Act, or NLRA, actually spells out what collective bargaining means. It states that collective bargaining is the process where a labor organization chosen by most employees and the employer meet to discuss issues like pay, hours, and work rules. Both sides are required to meet at reasonable times and to negotiate in good faith. This means they have to genuinely try to reach an agreement but are not forced to accept any proposal or make concessions. The NLRA makes it clear that both the employer and the employee's representative must perform their mutual obligation to meet and talk about work conditions. If either side requests, the results of these talks must be written into a contract. The law also sets rules for how negotiations should happen, including giving notice before changing or ending an existing agreement. In real life, collective bargaining covers many topics. These include pay rates, benefits, sick leave policies, safety standards, disciplinary procedures, and how to handle employee grievances. The goal is to give workers a voice in their workplace and ensure employers negotiate fairly with their chosen union or representative. The NLRA's definition applies mainly to private sector workers involved in interstate commerce. It protects employees' rights to organize and bargain collectively. It also makes it illegal for employers to interfere with these rights. The National Labor Relations Board, or NLRB, enforces these rules and makes sure everyone follows the law. So, to answer the question directly, yes, the NLRA does define collective bargaining. It provides the legal framework for how negotiations should happen and what topics they can cover, helping workers and employers reach fair agreements.